Fantastic. Thanks everyone for entering the room and welcome to the Australia at Home forum for today and today's discussion on our special subject of class actions. So where they come from, what they've achieved for Australia and or Australian society and individuals in Australia who've been wronged by mass wrongdoing and why they're worth fighting for. So if you've been in these events before, you won't recognise me. My name's Cameron Scott and I work with Maurice Blackburn Lawyers. I run our national stakeholder engagement team as part of our public affairs function. But for many years, prior to my current role, I was working in our class actions team on our corporate affairs side there. And so I've been heavily involved in watching how class actions have evolved over at least the last decade through my role there. Maurice Blackburn, I should say up front, is one of Australia at Home's sponsoring organisations, along with The Guardian and some others. So we're really proud to be contributing to today's forum, and I'll just go through some general housekeeping stuff before we get stuck into the heart of the conversation, and I'll let you know who the key presenters are today. Now, first of all, of course, we are, all of us, wherever we are in Australia, on Indigenous land. So I'm on the land of the Kulin Nation, and I pay respects to elders past, present and emerging, and recognise that the land was never ceded. Just some ground rules for the conversation today. For those who haven't been to one of these events, they're designed to be pretty relaxed. They're definitely designed to be respectful and very inclusive. We'll try and get to as many different views from the audience as we can. The ground rules are basically, to give you the best experience, turn your screen to gallery mode on the top right corner and turn your cameras on so we can get a sense of the hundreds it is at the moment, hundreds of people who have joined us for this discussion. It's a really good crowd. Open the chat at the bottom of the screen and introduce yourselves and put in questions for the panelists. I'll get those fed through to me. We'll try and get to as many as we can. And if you're having any tech issues, upstairs on tech support, so message her directly through the chat. Finally, you should be aware that we are videoing this and placing it online later. So if you are on screen, please keep it all nice. Let's get into the chat. So almost everything at the moment starts with some link back to COVID and the pandemic. The pandemic has us all on screen. But what on earth has COVID got to do with the evolution of the class action space in the Australian legal and political system? Well, the answer is very little in terms of new class action cases. However, COVID has presented the perfect cover, it seems, for political intervention in the class action space, at least at the federal level, where recent government announcements and the spectre of a political review into class actions have seen class actions become front page news. They've also become the subject of intense lobbying efforts on both sides to either tear down the system or to preserve it and preserve the role it plays in providing everyday Australians with important access to justice. So today we're going to look at what class actions have contributed to Australian society. And underpinning that discussion is a very basic proposition. It's about who has legal rights in Australia and who then gets a chance at exercising their legal rights when they've been wronged. So is it just the case that, wealthy and privileged entities and individuals can and should have that right? Or does it go to the notion that, my rights are all of your rights on the screen, and there's an equality in the protection we enjoy from having those rights, as well as our ability to exercise those rights? So to explore that, we've got what I think will be a really informative couple of key speakers today with some really different and insightful perspectives. Rebecca Gilsonen is one of the country's most experienced and successful class actions litigators. She's a principal in Maurice Blackburn's Sydney office. She's also a board member of the firm. And she's run some of the biggest class actions the nation's seen, including the South East Queensland floods class action. The other key speaker today, and I thank him very much for fitting us in during the current parliamentary sitting in Victoria, is Victorian Upper House MP Rod Barton from the Transport Matters Party. Now, Rod has a really interesting position to be viewing all the clamour around class actions at the moment, because he's a member of a large class action against Uber, and he was instrumental in helping to bring that action to life. So he knows how hard it is to get a class action up and what it's like to be a group member as part of one. But he is also on the crossbench in the Victorian Upper House, and so at the moment he has been subjected to intense lobbying from all sides about a bill that directly deals with how to make class actions better for participants. You know, it's possible that some of the vast audience we have joining us today have had their own class actions experiences. So I'd definitely encourage you to get involved also if that's the case. But to kick things off, Rebecca, given we know it's not something everyone has had an involvement in, probably worth you telling us a bit about how class actions sort of came about in Australia and what types of things have become class actions in Australia, just so everyone gets a bit of an understanding of what they can do for everyday Australians.
Sure. Thank you, Cam, and thank you everyone for coming. So to start with some fundamentals, class actions have been around in Australia for hundreds of years, but the modern regime was introduced in the Federal Court in 1992 and broadly followed the recommendations of an Australian Law Reform Commission inquiry around access to justice. Similar modern regimes have been introduced in most states in Australia since 1992. So what is a class action? It's a procedure that allows claims to be grouped together. And to be clear, it's a procedural mechanism. It's not a new right. So you have to start with an existing claim, or you have to have been the victim of some form of illegal conduct. And if that conduct affects numerous people, then the class actions mechanism allows those people to band together to bring their case together. So at its heart, it's a procedure and a way to access the justice system. And to employ an example, there's been a few cases in recent years against payday loan providers about the exorbitant interest rates that they charge on their payday loans. That conduct was said by those class actions to be illegal under consumer credit legislation. And the individual losses suffered by the people who were paying ridiculous interest rates on payday loans were in the hundreds, thousands, and sometimes tens of thousands, but not more than that. So putting aside the financially precarious situation of people who need to use payday loans, it wouldn't make economic sense to try to use the justice system to hold the lender to account for charging illegal interest rates. It would cost you a lot more than the damage that you suffered individually. Even if it ran into the tens of thousands, that's probably still very likely to be the case. But when you have 20,000 people affected by the same conduct, which is what occurred in some of these cases, they can band together and bring their case and obtain compensation for that conduct. So at their heart, class actions have a lot to do with who can use the courts and who can be held to account for illegal conduct. They shift that balance. In most instances, outside the context of class actions, it's really only very wealthy people and corporations and very poor people where legal aid is available who can in fact make use of the justice system. But class actions make, in circumstances where mass wrongs occur, make it much more accessible for everyone in between the very wealthy and the very poor to be able to exercise their legal rights. At the moment, I'm sure everyone who's sitting in the audience today has seen quite a bit of this, but there's an exaggerated focus in the media on shareholder class actions. And in order to, I guess, balance up that perception, I want to give some examples of recent class actions that are about people exercising rights that aren't anything to do with shareholder rights. So yesterday, 300 beef exporters won a claim for compensation for loss of income against the government in a misfeasance in public office case. In recent weeks, the threat of the robo-debt class action for compensation on behalf of social security recipients forced the government to commit to paying back $700 million that was illegally taken from those people. A couple of months ago, the owners of contaminated land around military bases secured a settlement against the Commonwealth for $200 million to compensate them for the loss of value of their contaminated land. And late last year, the Queensland floods case resulted in a victory for the residents and businesses of southeast Queensland, who lost so much in the 2011 Queensland floods unnecessarily and because of the negligent management of the dams above Brisbane. There's been a raft of recent class actions against payday loan and consumer credit providers for charging exorbitant interest rates to some of the most economically vulnerable people in Australia. Another example is the Depew hips class action, where thousands of Australians were implanted with faulty metal-on-metal hip implants that caused them, in some cases, incredibly debilitating injuries, and in many cases, at the very least, another episode of major surgery. And those people are now being compensated and having their medical care paid for by the manufacturer. Just recently, Volkswagen settled the class action in Australia on behalf of the Australian victims of the diesel emissions scandal. There's class actions about price fixing against Amcor and Visy, which affected all segments of the economy, from listed companies to private producers. In fact, everybody who uses a cardboard box or buys a cardboard box. And I guess more recently, there's been a raft of actions arising out of the conduct that was exposed by the Financial Services Royal Commission. And those are largely consumer actions on behalf of superannuation account holders who've been ripped off by the people that they relied on to manage their superannuation savings. Now, all of that said, and given all of those examples, shareholder class actions occur, and they actually fulfill a really important role. Any Australian who has superannuation is an investor in the Australian market, and we all depend on having an honest and efficient market to protect our investments and to ensure prosperity and the reputation of the Australian market for investors both in Australia and overseas. And look, that the role played by shareholder class actions in ensuring the integrity of Australian markets has been recognised by regulators, and the private enforcement role has been recognised by regulators as being complementary to the role that they play in regulating and managing the integrity of Australian markets.
Yeah, and I think that's really an important point, Rebecca, about that you make with the breadth of those cases. You can see that partly just because of the nature of globalization and the fact that large companies service large numbers of clients, when there is a mistake that happens, it generally affects a lot of people, and there's a lot of different areas that it affects them across, as you mentioned there. On that last point, because there is so much attention on sort of shareholder class actions, some people, is it fair, I suppose, for some people to consider class actions as a last resort, or where do you think class actions fit in terms of ensuring enforceability of the law or accountability in the Australian landscape? Because it's not just class actions that can do that, right?
No, there's regulators like ASIC and the ACCC and other regulators who play their public enforcement role, but particularly as the Financial Services Royal Commission illustrated, and indeed the regulators themselves accept, their ability to fulfil their roles is limited by the budgets that they are given. And they, in the aftermath of the Royal Commission, they were screaming out for bigger budgets to actually play the role that they were being called upon to play. But as I say, they have acknowledged in lots of different forums, including to the Australian Law Reform Commission, that private enforcement in the form of class actions plays a significant role in completing that picture. And in my personal experience in some of the shareholder class actions I have run, for example, against Guns Limited and Leighton, the regulators were acknowledging that there were certain things that they didn't feel, once a class action had begun, they were able to remove their budget from trying to enforce that issue, take it to a new issue, because they were confident that the shareholder class action would actually fill that gap or perform that role of enforcement of those rights. So shareholder class actions play an important part of that picture of regulation and efficiency in the markets. But I would say, in a sense, they're a last resort in a sense for the people who are participating in them, because they would much prefer not to have to litigate to have their rights restored. So I guess in that sense they might be seen as a last resort, but not as, in terms of the regulatory picture, they're an important first line, I suppose.
Yeah, and it's an interesting point you make about, they're a market-based mechanism in the context of the political debate that's happening at the moment. On that, it's probably a sensible time to move on to our next speaker, Rod, given that we're talking about the political context and that Rod's dealing with it firsthand in the Victorian context around contingency fees. And also, Rod, I suppose that people might be really interested in hearing both of those things from your perspective of the last resort and how hard it is to get a class action up and running already in the current environment, and then what the future might hold given what's happening in the political sphere at the moment. So did you want to give your personal experience, I suppose, at the start of what you've experienced trying to get the Uber class action off the ground?
Thank you, Cam. Yes, the Uber class action, we started this probably 4 years ago, and well before I had any inclination that I was going to end up in Parliament, but it's all been part of the journey. 4 years ago, myself, my very good friend Andre Baruch, and another mate of ours, Nadav Prower, we were sitting around the dinner table, and we couldn't believe that a company like Uber was able to operate within Australia, not doing the odd thing wrong, but actually operating completely outside the law for years. And because we had a basic principle that we believed that those who are working within the law should be protected from those who are breaking the law. And it was clear, not only here in Victoria, but around the country, regulators were turning a blind eye to their actions. So we had a discussion over dinner one evening, and at the time I was actually president of the Hire Car Association. Andre was my vice president. And the discussion came around from our Nadav, who happens to be a lawyer. He says, what we should be doing, because we were displaying, we really wanted to go after the government. We felt the government the industry had felt that the government had failed taxi and hire car drivers in this country, particularly in Victoria. So we weighed up all the options, whether, what's feasible, what we could do, what do we believe in, can we go the government, can we go the regulator, can we go Uber? And Nadav actually come up with this, he said, the best opportunity we think is to go after Uber itself, which we all fell off the chair, thought that he actually had a few more drinks than he should have while we're having dinner. But from that position there, because of the Hire Car Association, we then started getting other opinion. How strong is this? So because of the industry we were in, I was still running a hire car business. We had access to lawyers and QCs, and so we bounced that thing around. And repeatedly, what was coming back to us is that this would be a viable option, but we need help. So it was only then, and we still didn't really believe in ourselves that we could actually get this to happen. It was only when we took our position to Maurice Blackburn and got Maurice Blackburn to run the ruler over it. Then they come back and said, look, we think there's an action here. We think we can proceed with this. So we got a little bit excited about that. And but it was only when the litigation funder, we got the news that the litigation funders come in and backed us. It vindicated all the work that we had done. And I can tell you, it took us probably nearly a year to get to that stage. But when we had a litigation funder who said they were prepared to put up a bit over $20 million to back us, it made us feel like we haven't wasted a year, and it gave us confidence that people far smarter than us believe this should be happening.
And so were you surprised, Rod, just at how much effort and work and time and energy you had to put in just to get it, to the start line, basically?
No, It was staggering, Cam. All of these things, we had spent tens of thousands of dollars.
Yep.
There's a bit of money from our own pockets and all that went into all of this stuff. There was getting different legal advice, trying to get ourselves in a position that we could eliminate. And what we're really proud of, Andre and I, is that we haven't asked our members to pay for anything.
Yeah, so that's an important part that I think is worth just being quite clear about for everyone. The way class actions are run in Australia generally, at least by our firm and most of the other big ones, is that they're either funded by a third party, so you, the group members, don't have to fork out of your own pocket to keep the case rolling, or the law firm funds them. And what Rod is currently, and his colleagues in the Upper House in Victoria are currently considering, is whether or not to act on the recommendations of the Productivity Commission, the Australian Law Reform Commission, and the Victorian Law Reform Commission, which have all suggested there's a better way or another way, which is to have contingency fee arrangements, which means that you don't then need the third party funding it. The lawyers can fund it for a percentage, and then more will go. So, more will go back to the clients. If you think about having to pay the lawyers, the funders, and the clients, you take that whole middle tranche of having to pay the funders. So that's what Rod and his colleagues are considering at the moment. I mean, you guys all, I suppose, well within your rights to keep your cards close to your chest if you want, Rod. But yeah, what's the kind of mood in the upper house about what people think about just providing what is effectively just another billing option, which seems far simpler and has been recommended as one that can deliver far more to claimants?
I can't speak for my crossbench colleagues, but they're certainly all receptive to it. But I can certainly speak about my own view. There is no doubt that if this this bill gets through, and we were bringing our case now, those 7,000 registrants would be better off. There's no doubt about that, because currently under the old system, which the Uber class action that we're taking, all those 7,000 people who have been wronged, we have to pay the litigation funder, and we're going to pay them somewhere between 25 and 30%, depending on if we're successful, of course. Then we obviously got Maurice Blackburn's fees on top of that. Traditionally and historically, it would probably add another 10%. So roughly around 50% of any settlement doesn't get to the registrants. If we have if we're in the new system, if it gets up, is that, and I don't want to speak on behalf of Maurice Blackburn, but to say if they had a contingency fee of say 25%, there'll be 75% going back to those registrants, those people who have been wronged. And that's where that money should be going. There was a, sorry, Ken.
No, I was just going to say, I just want to pick up Rod, because I think you make the point quite well with that example, and it kind of is that stark the example in terms of the split and how much simpler the system could be and more beneficial to the clients. But you mentioned there the 7,000 odd registrants and group members in the Uber class action. I just want to pick up on one of the questions that has come from one of the participants here today, out of space, Nick. If I presented a strong case for a class action, and Rebecca, we might go to you on this in a second as well. If I presented a strong case for a class action, does Maurice Blackburn advertise for participants, or do I have to find a certain number myself before I bring it to the law firm? Rod, I might just go to you first, because how'd you go about getting, so I should just say for everyone, you require a minimum of 7 to form a class. Rod, how'd you go about getting the 7 and then multiplying that by 1,000?
We had many thousands of taxi drivers and hire car drivers who have been wronged. I was the boss. I was running a hire car company at the time, and I was also president of the Hire Car Association, which took in taxis as well. I had no trouble getting the numbers to make it worthwhile. But what blew me away is how quickly the action travelled around Australia. Very proud that people, a lot of the people involved in our class action, English isn't their first language. They're hardworking people. They live week to week. They get terrible paying conditions. And it's fantastic that we've been able to support them like this.
And Rebecca, I suppose, given that you've run a breadth of cases, that you ran through a list of some of those before, yeah, I imagine, and I know, it's not that easy, is it, to get to everyone who's been affected by a mass wrong? Like, you can't ensure, can you, that everyone reads a newspaper or gets get some online advertising, whatever it might be. But what do law firms do to try and make sure that, if I've suffered a wrong and there's a class action, I'm not just sitting in my office at home oblivious to it, and I actually am aware of it, and my rights are protected?
So there's a range of steps that we'll take at different stages that range from advertising is one method that we might employ sometimes. Often when you start a class action, there's a degree of media interest, and so the media will write about it, and we'll try and ensure that we're mentioned there so that the people know where to come. We might work with, and the Uber class action is probably the perfect example. If you've got a professional body or bodies or networks, they'll often take care of the gathering up themselves. You might go through doctors if it's injured patients. I mean, doctors who've implanted faulty medical devices are usually desperate for their patients to have a solution, so sometimes they might help. So it depends on the particular problem and what what the right solution is to get in touch with the people who have experienced that problem.
Yeah.
Also, after the beginning, sorry Cam, I'll just quickly cap off by saying after the class action begins, there's a number of formal notice points that the court's involved in. And at that stage, we'll often use the defendant's records. So either their share register or their records of all the people that they've provided a payday loan to, or that type of record to actually write directly to everybody who's been affected by it. So there's quite a few junctures at which we will try and get in touch with the people who are affected by a class action, including a few very formal junctures. It's still, often imperfect, but, I think we do end up getting in touch with the majority of affected people by the time the class action is finished.
Yeah, it's an important point to sort of highlight, because anyone who's involved in this forum might be interested in, one day, how do I exercise my rights? And you do need a level of vigilance, but it also helps inform the current debate that's happening around either helping class actions cover all people's rights or really trying to diminish class actions and trying to stifle them. I might just go to Robin and get through some of the questions that we are starting to get through on the chat. And thank you to everyone for bringing some of these questions up. Robin has got a really interesting question that I think she might like to put to you, Rebecca. Robin?
Yeah, Rebecca, I'm interested in what I've heard is a class action being run by a group of people seeking asylum against the Australian Government / Home Affairs on the grounds of illegal detention. There's not a lot been around in the mainstream media for reasons that we would all understand about this. And I just wondered, none of those people by definition are Australian citizens. So, presumably you don't have to be an Australian citizen to run a class action against the Australian Government. And I just wondered if you know any more about that. I'm interested in it because of my association with the Asylum Seeker Resource Centre as a volunteer, although I'm in recess at the moment.
Okay.
Thanks.
All right, so to the first and fundamental question of whether you need to be an Australian citizen to either bring or participate in class action, the answer is no. To the second question, I'm not sure which one you're talking about. There was one, a class action that was run by Slater and Gordon on behalf of a group of asylum seekers that settled for quite a substantial sum a while ago. There's another one, I think, on foot in relation to healthcare being provided to asylum seekers. But if you allow us to keep your contact details, I can look into that after the session and see if I can provide some information and find out where it's at for you.
Well, I'd love that. Thank you. I'd really appreciate that. It'll be good to see an outcome, particularly for those people who came here hoping to get healthcare and who've in fact been provided with you know what. Thanks.
I think there was, sorry to step over you, Cam, but I think there was another question as well from somebody about class actions for another incredibly vulnerable group, which is Indigenous people in Australia. And I am aware of one which I think is was a terrific action, which was to recover stolen wages for Indigenous people in Queensland that settled last year as well, and another one in relation to the Palm Island riots. So they're the only two that I can think of, but it is another example of class action mechanism being employed for really vulnerable groups.
Yes, and thank you to Leonie and Frank for putting that topic up. That was a really interesting one to get to. Another interesting, well, a couple of interesting ones before we perhaps move on to why the current climate's so hot on class actions at the moment. I might just go first to the floor at Ariane. Ariane, I think, has a really interesting one, Rebecca, that you might like to address, which goes to something we're all overtly aware of at the moment around digital rights and privacy and those type of things. What's your experience in the class action space, Ariane?
Hi, thanks so much for the topic. Yeah, I am one of the class actions against the Cambridge Analytica and Facebook digital breach. So I didn't fill in a form, but a friend of mine in the US, I believe, filled in a form and my details were given to Cambridge Analytica without my consent. So my question is around the importance of privacy now that we are going into a very digital age. How do class actions sort of enforce the privacy laws, and what role are they going to play in the future?
Okay, so there's been a few privacy, it's a very embryonic area. Let me start by saying that. And you'll recall right back at the beginning, I said class actions isn't a new right, doesn't give you a new legal protection, it just gives you a mechanism to bring cases that affect a lot of people. So privacy class actions go back to our privacy laws, and we've got to think about the state of development of our privacy laws. And I have to say it's pretty early days in terms of proper privacy protections in Australia, and there is a lack of clarity about whether there's a private right to compensation for data breach type events or release of protected personal information. So the Cambridge Analytica class action is one of the two, I think, that are currently on foot. There's also one about the Optus data breach. And there was an earlier class action on behalf of a very small group of paramedics whose personal health information was stolen when they suffered work injuries and sold to some unscrupulous, sold by unscrupulous people to lawyers to pursue them to run their case. So I think the data breach class action area, we will learn through one of these class actions soon whether there is a private right to enforce, to seek compensation in relation to a privacy breach. And I think that's, you know, if that right is held to exist and there's some compensation available for people for that, I think we'll probably just see more, because, you know, the way that we operate is in such, you know, so data dependent and large scale and so on. So I think it's really an area to keep an eye on.
So I see Bedlam Bay sitting there in the glorious sunshine. Could a class action be undertaken for the sports rorts scandal? I think that's a really interesting one to Rebecca. And I think we might even, in some capacity, have looked at helping some people regarding sports rorts in other parts of our firm. Is that right?
That is right. It's not at the moment a class action, but it could become so. So I think it's a good question, and I think the result of the cattle export case about public misfeasance in public office, their success there on an incredibly difficult cause of action just yesterday is probably something that's worth thinking about in the sports rorts context as well. So it is possible.
Yep, and Rod touched on something in what he was mentioning before, which Nina has asked in the chat a little bit more about. Can regulators be accountable? Like Rod was expressing that the people he was trying to bring the Uber class action with were looking at, you know, a whole range of other people that were unhappy with their actions. And so Nina's question is, can regulators be accountable for change, or do class actions assist more to enforce this? I suppose I'd just probably start, Rebecca, before throwing over to you. I think that class actions are an important part of the enforcement matrix we have in the country. And Rebecca, you might need to elaborate a little bit more on the fact that we do have private and public enforcement, but there's no real reason, is there, Rebecca, that the two can't work as a complementary force?
Yeah, look, ideally they would, because private regulation performs an incredibly, both of them are important, but public regulation performs a very important role, and public regulators have more powers and powers to compel companies to give information, answer questions and so on than private enforcement mechanisms or private enforcers do. So ideally, it's complementary. Where public regulation tends to stop is at getting compensation or redress for the people who are affected by the wrongdoing. So public regulation tends to stop the conduct or that specific conduct, but it doesn't usually get a remedy for the people affected. So that's where private regulation comes in and is very complementary. And often the amounts of money that are extracted by private cases, so class actions, is very much greater than the fines that the public regulators manage to secure in Australia. So in that sense, they're complementary, and in, I suppose, to the extent that we can say that the risk of having to pay over money influences conduct, I think private regulation can often be even more effective in that respect.
And I think that probably leads us through to the current sort of public and political debate that we're in the midst of, which we might just move to now. The current threat facing class actions, I think, is really because they have proven in large part to be such a great disincentive for corporate wrongdoing. And, you know, Rebecca, who's really driving the current threat to the class actions regime, and just, can you give people a bit of a flavour of some of the things they might be reading in the media at the moment, and what's driving a lot of that this hostile environment towards, you know, what has been a pretty effective regime for the best part of the last 29 years?
I might try that in two parts, Cam. First with some facts, and then second with who's behind this.
Sure.
Besides the obvious players. It feels to me that that class actions are in the news a lot at the moment, more for the wrong facts than the right reasons. The language that we keep seeing is explosion, crisis, crippling business, directors can't decide anything, this type of thing. But I just want to put that in perspective. 1% or just less than 1% of listed companies face a class action in Australia each year. And over the past 2 years, the numbers of class actions filed throughout Australia are in 2019, 44, and 2018, 55. That compares to 2,800 filings of commercial litigation in 2019 in the federal court alone. So you can assume that that's double or triple by the time you take into account the states. No one seems to care about companies suing each other. It's just when their employees or consumers or shareholders sue them that the agitation seems to wind up. So firstly, I don't think there is a real crisis that we are facing. Secondly, I keep asking myself, why is everyone complaining about the number of class actions, and why aren't we questioning what conduct's giving rise to that? Why isn't there a crisis of corporate behaviour, for example, rather than a crisis of class actions? Class actions are based on something. So I'm constantly befuddled by the fact that we're not worried about the behaviour, we're just worried about the redress that follows it. So then to answer your question about who's behind this, Cam, I think we'll probably come to talk about the inquiry shortly. So I won't say anything about that so much as, quite obviously, it's the current government at the federal level who's driving the reforms and the announcement of inquiries and so on. But we're also seeing some influence from the US Chamber of Commerce. Their kind of finger marks are over a lot of this, and there's some great investigative journalist pieces in Crikey and elsewhere that you might want to look into if you're interested in that.
The Guardian, probably, they've done a decent job.
Yeah, exactly. So a range of outlets have done a good job. What we saw though was when Fairfax was acquired by Nine, we saw quite an obvious change in editorial policy, which was more about editorial policy than a change in circumstances. And the News Corp outlets have been working tirelessly to push a particular point on this front as well. So I might stop there and let you talk about inquiries and things if you want to, Cam.
Well, I'd be interested to go back to Rod at the moment. Rod, I think it might be quite fascinating for everyone in the room, and I'll find it fascinating too. I mean, you're a crossbencher, so you're caught directly in the middle. You've got both sides sort of coming at you with competing interests, and you've got the lobby group sort of knocking on your door. What's been your impression of, I suppose, what's driving it at the political level that you're seeing, and what do you think the motivations are for the various bits of lobbying that you've been subjected to?
Those two. If I can just say, Cam, just before I answer those parts, is that let's let everyone know that I'm not a career politician. I'm here because of what happened to the taxi and hire car industry, who have been wronged so badly. We set up a political party 7 months out from the last state election here in Victoria, formed a political party, rallied the troops, and we actually pinched a seat. We come very close to grabbing a second one. So I say to my taxi and hire car people, thank you so much, and the fight goes on. There is no doubt, Cam, this has been a Conservative agenda. They have come after me personally. I've got a conflict of interest, even though what's going on, I'm one of 7,000 registrants in a case. But they've come to this that I shouldn't be involved somehow in this debate. Apparently it didn't pass the pub test, according to Mr. O'Donoghue, for the Liberal member in the upper house. I probably wouldn't pass the Melbourne Club and the Australia Club, but it's certainly the pubs where I go to, they're certainly they're on board. In terms of what's being driven, there is no doubt that the feds are actually going to run another inquiry because they didn't like the result of the previous 3 inquiries. They want an inquiry that matches what where they want to end up being.
So I think that's a really important point, just to pick up on, Rod. Certainly from my perspective, it's important. I mean, and to go back to the opening where I said most things are tied back to COVID, and it looks like they've got a bit of cover from COVID. Already, when we're in this circumstance where, money's at a premium for everyone in society, we've already spent serious money on inquiries by independent players, the Productivity Commission, the Australian Law Reform Commission, and the Victorian Law Reform Commission, all concluding the system largely works well, all concluding independently that contingency fees could make it even better for clients in terms of their eventual outcomes. Do you feel like it's a waste of public funds and, operating in this post-truth sort of politics environment that we then now have a parliamentary committee to do the exact same thing when they haven't responded to the other reports?
Cam, absolutely. There's no doubt about that. It's a complete waste of time and a waste of public's money. We should be absolutely, there's been 3 major inquiries and they've all come up with the same result, and this is what we should be doing.
Yeah, okay. All right, well, that's a fascinating sort of insight from the crossbench. Have you, when you say you've been, that they've come at you, how hard has the lobbying been to get you to do one thing or the other?
Well, they certainly, there was complaints that I've had the 2 daily newspapers and the Australian newspaper, they've all contacted me about my alleged conflict of interest after speaking with them. And the reason that was come about is because I asked Maurice Blackburn to come down and brief the crossbench about the facts. When we told those newspapers about the weeks prior that Mr. O'Donoghue, on behalf of the Liberals, brought in the Australian Industry Group but it was perfectly all right for them to brief the crossbench. But it was a different situation when I wanted to get make a level playing field, so they heard both sides of the story. So they're trying to do a bit of a media job there. They haven't been able to get any traction because there's nothing there.
Are you, do you spend some days just wishing you were back driving the car and not sitting in the upper house having to deal with all this? Or are you pretty happy with the transition that you've made?
I miss the people. I absolutely miss the people. We used to drive, one of my favourite clients was a 90-year-old Collingwood supporter. She would go to the footy, and we used to all worry about her getting to the footy, and we right up to some of the highest profile people in this country. It was pretty awesome, a cross-section of people. And it's a different world in politics.
Yeah, it sure is. Rebecca, I might just come back to you on something which is a central sort of bugbear and a central concern at the heart of a lot of the public debate. You touched on it before that, you know, class actions follow an event. They don't provoke an event, they follow an event. Yet a lot of the focus is on fees and how much it costs. So I think it's probably worth, just for the benefit of, you know, everyone who may not have really been involved in a class action and who may end up one day joining, can you give everyone just a quick overview of, you know, are these expensive cases to run? Are they hard to run? Because I think everyone assumes they're a lay down misère when you lodge them. And what is it on the cost that sort of protects people and differentiates us from the US?
Sure. Okay, so
I'm sorry, I'll come back to it if you want.
I've written myself a list, Cam, so I don't miss any of those. Expensive, yes. These cases costs are generally at a minimum in the millions of dollars zone, if not more. The cost depends very much on how quickly the other side comes to the table. So sometimes, and not often, but very, very occasionally, I've managed to reach an early resolution with the wrongdoer, if you like. And I think I might have finished some of these cases for less than $1 million because of their willingness to work together and solve the problem quickly. And frankly, that's always the best outcome for our clients, not just because the fees are lower, but because they're not waiting and they're not wondering what the outcome might be, that these things go on for a long time sometimes. That leads really into, are these cases hard? Good God, yes. I mean, I wish it was as easy as this kind of green mail story where you start a class action and somebody shakes out their pockets for you. I mean, the reason they're expensive and the reason they take a long time is because the opponents fight like mad, and often with all sorts of tactics and applications and things that really put the end result or the resolution further away from us. So like I say, the main factor about how much these cost is what the response is of the other side. If they have a kind of quick and responsible response, the fees aren't huge, but there's plenty of examples of the opposite. There are a range of cost protections for consumers or litigants on the plaintiff side of class actions. What they aren't very well protected against, though, is the conduct of the other side. So their own lawyers, so us plaintiff lawyers and indeed funders, are heavily scrutinised by the courts. We can't get paid anything unless it's approved by the court, and they'll look through, and if they think that there's anything that's unreasonable in there, it will get lopped off. But I guess most fundamentally, in terms of the system more generally and what protects us in Australia and distinguishes us from some of the other class action systems that are painted as the bogeyman in some of this discussion, for example, the US system, is we have an adverse cost system. So that means in litigation in Australia, if you lose, you pay the other side's costs, and if you win, the other side pays most of your costs. In America, that isn't the case. And what that means is that, you know, in Australia, someone is very, you know, a litigation funder, for example, or even a law firm who's not getting paid along the way and only gets paid if they win, is going to be very slow to file a case where, if they're not successful, they're going to have to pay the costs to the lawyers they've employed and the costs of the other side. So I think that's a fundamental difference that will keep our system different to the US no matter what happens.
Yeah, I think that's an important distinction. Okay, so we know that there's a range of mechanisms that make sure that people can currently band together to exercise their rights. There are a range of mechanisms, whether it be no win, no fee, or litigation funding, or potentially the introduction of contingency fees, which mean that people don't have to shell out of their own pocket along the way to keep these big cases rolling against large, powerful defendants. Rebecca, I suppose first point, as we try and wrap up today's session, what is the cost of damaging class actions if the business lobby who's out there gets their way?
Well, I guess there's the immediate cost and then the cost to the system in our society. The immediate cost is that people who've suffered illegal conduct will not be able to use the justice system to get redress. So there's whatever is being sought in the class actions, but there is the bigger cost of the undermining the integrity of the Australian market and the cost to prosperity that comes from that. And I talk about, in that context, I'm talking about shareholder class actions, but there are other costs in all those sorts of areas. Consumer cases, if superannuation account managers aren't held to be responsible for actually acting like trustees of our money rather than companies that are trying to enrich themselves, we all bear a cost throughout society. If faulty medical products are on our market, there's the human cost of the injuries, there's the cost to the government of paying for the medical care, and there's the cost to the private medical insurers of having to pay for medical care that was caused by that. So the costs really do, there's the immediate access to justice and people being able to get redress for the wrong that they've suffered, but there's the implications for society and for market integrity, for safety, for payday loan sharks knowing that people are watching them and they can't charge vulnerable people 50-60% interest on a payday loan.
Yeah. And I mean, you reeled off a breadth of cases you've been involved in earlier. People in the chat have noted things like climate change, robo-debt, other bad government decisions. It sort of comes back to this fundamental proposition that I mentioned at the start, which is, there is no reason, I don't think, that people shouldn't be able to exercise their rights or should be limited in our legal system just because they're not wealthy or they're not, famous or whatever it might be. Rod, I mean, I might just sort of round out what is the cost? I mean, what would your options have been in representing yourself and all of your fellow drivers against Uber, for example, if the class actions mechanism either wasn't available or it was so ridiculously prohibitive trying to get one going?
Cam, that's an easy one. They would have got nothing.
Yeah.
We wouldn't be in the fight right now. And I know everybody's frustrated at the amount of time these are going, but I know everybody who's working for our class action is doing a fantastic job. But without the class action mechanism, we would never have got it up. They simply had no money left. There was nothing for them. They would not have been able to get justice at all.
Yeah, and I think that's representative of a lot of the large groups, at least that our firm ends up representing in class actions, which is, to go back to the last resort thing, there's not a whole lot of other options to hold big, powerful entities accountable, try and affect some type of change. And that change should filter out throughout society, as Rebecca has kind of mentioned, across a whole range of areas for other societal benefits. And on the numbers Rebecca's talking about of different cases, it's nonsensical to think that class actions are some sort of scourge that's going to upend the economy. All right, well, we are coming to the conclusion of today's Australia at Home Forum. I greatly appreciate everyone joining in, and thank you very much to everyone for the wonderful array of questions and inputs you've had through the chat. Thank you very much to Rod and Rebecca for your insights. I think they're really interesting insights, especially given you both right down in the trenches in different ways and dealing with a lot of these things. The sponsors of Australia at Home need a special mention, of course, as well. Essential Media, Principal Co, The Guardian Australia, the Centre for Australian Progress, and of course, my very own Maurice Blackburn. I'd encourage you all to continue attending this wonderful series of events. You know, join Australia at Home every day for a discussion like this. Tomorrow, if you want to come back, the history of pandemics with Emma Dawes and Professor Janet McCalman from Melbourne Uni, and a panel of international experts. So I hope that you got, I know it's kind of a crash course, I hope you got something useful out of today's session. Please, if there are extra pieces of specific information you'd like to follow up, either with Maurice Blackburn via me or Rebecca Gilson, or of course, you know, if you want to talk more to Rod Barton about what's happening with the Victorian Transport Matters Party or the Uber class action and his views on that, I'm sure he'd welcome you contacting him as well. And aside from that, I will let everyone get back to their day and greatly appreciate you all joining today's discussion. Thank you very much.